feeling like I'm Akademiks. Can't ride away.
Perfect. Cool. Let's get a little quick Diddy update. By the way, Diddy's trial is starting. Oh, it's May 1st. Fuck, it's May 1st? It's officially May 1st. By the way, 2 weeks until our show, birthday show. Please go cop some tickets if you haven't yet. Ticketmaster, just search up DJ Akademiks, DJ Akademiks Live Podcast. I would love to have you out there for my birthday show. Appreciate y'all. Now, here's the other thing. It's 4 days officially from now until Diddy goes to trial. So Diddy's going to trial. All the pushbacks have been, denied by the judge. They want this thing to start on May 5th, and they're going to pick a jury. Then they're going to get right into the trial. They've been kind of arguing about what could be, some pretrial stuff, what could be mentioned in court, what can be mentioned in court. But I expect that jury selection should happen within like 2 weeks. So by no later than the 20th, I would imagine that the first day of trial would be happening. And we should get a conclusion. If you ask me, I think that trial should be done in a month. So if we go from May 20th to like June 20th, let's just call it July. By July, I think we should probably have a verdict. Unless something unprecedented or some random circumstance happened that they push all this stuff back. But that's how quick the federal government is really moving along with this case. Now, apparently Diddy is trying to have a mental health defense. Like he's kind of like gearing up, and they kind of submitted to the court that they want certain things to be allowed to be introduced that they could claim as a particular defense about Diddy's either, state of mind or whatever the case is. Check this out.
Potential mental health defense, to propose questions to potential jurors as they begin showing up to court. We're going to get into the latest filings and developments as the sex crimes trial for Sean Diddy Combs is about to begin. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Okay, so before we jump into the case, I want to tell you about something else real quick. We have this brand new podcast that we just dropped on Wonder Race, where he faces 5 counts: racketeering, sex trafficking, transportation to engage in prostitution. And we're going to get to the questions a little bit later on about what these jurors may be asked, and what the process may be. But there has been a flurry of new activity on the court docket leading up to this trial. So many issues that need to be sorted out. So I want to go through them. And the first one, this is something. So first, we have a interesting defense that was possibly laid out by Sean Combs' attorneys. And it appears the defense wants to argue to the jury that Combs had a diminished mental capacity, meaning we're talking about a mental health defense, that he couldn't properly form the necessary criminal intent, we call it mens rea, to commit the offenses that he's charged with.
Now, that's very interesting, right? So sometimes intent matters in what you're being charged with. Were you in the sane or capable mindset of doing these things on a premeditated level, or actually you would have to have some mental capacity and be fit to have an organization run something that's criminal, right? And he is charged with RICO here, which is a criminal organization type of charge. This clip is probably going to be used, right? And it's going to be the Diddy Speech Awards. I think it's at the 2022 awards show, and this is probably going to be used in that speech. Listen.
Yeah, I'm going to keep it 100 with y'all. I was in a dark place.
I think that's 100% going to be used, where he basically admitted that in the years following 2022, he was in a dark place, maybe depressed, maybe going through other mental health issues that probably, prevented him from operating in the sane way of processing and figuring out or doing whatever needs to be done. Not saying he's admitting to any guilt, but just saying that he was mentally incapacitated to some extent.
100 with y'all. I was in a dark place for a few years, you know what I'm saying? And I have to give a special shout out, thank you, all that love. Cassie for holding me down in the dark times. Love. Yeah, I'm going to keep it 100 with y'all. I was in a dark place.
Okay, and he also shouted out Cassie during that moment as well.
More specifically, it seems Combs wants to call Dr. Elie G. Aoun, MD, an assistant professor of clinical psychiatry at Columbia University and forensic psychiatrist in New York City. Hopefully I'm pronouncing the doctor's last name correctly. I apologize if I'm not. But the government claims that Dr. Aoun didn't examine Combs, but looked at all these records. And what he plans to opine about is not 100% clear because so much is redacted and blacked out in the filings. However, there are references to whether a defendant is lucid or whether a defendant can control his behavior and volitional acts and, quote, evidence of the effects of drugs and alcohol on a defendant's memory or cognitive function. So is the idea that Combs was so heavily intoxicated that he didn't know what was going on, that he didn't have the proper criminal intent to commit these crimes? So before we get into all that, I want to explain why the government says Dr. Aoun's testimony should be excluded from trial. And essentially, it seems that whatever defense the defense is coming up with, they say it shouldn't be allowed to come in. So first argument is that under federal law, usually a mental disease or defect is usually not a legal defense unless we're talking insanity. However, there's a rare and narrow exception where a defendant can introduce mental health evidence to argue that there was no criminal intent. And because
that's also interesting, and shit, I'm learning as well, right? So usually when we hear about mental health being a defense, we're thinking about someone who's down to plead insanity. Now, when you plead insanity, you're almost kind of usually giving up the obvious, which is, yeah, I did all that shit, but I didn't, I wasn't within my sane mind. Diddy's not saying he did that, but he wants to use mental health in the way of saying, hey, I was going through some shit and all my decisions during that point could not be used as being malicious or in a premeditated way. And it's kind of used to try to take the sting off whatever they might prove. And that's what I got to think about it. Or some of these acts that they're actually alleging requires intent. So if you take the intent out, you actually help Diddy's case of maybe possibly getting found not guilty.
Because it is so rare and so narrow, the prosecution argues that the defendant has to establish a direct link between the evidence and the specific intent required under the charged offenses. And under the federal rules, the defendant has to provide the proper notice to the government before they can introduce evidence about this. So the government argues that other rules apply to as well. There's Rule 702 regarding expert witnesses and qualified opinions they can give. There's Rule 703. It puts limits on when and how experts can testify to facts and data that are usually inadmissible. Rule 704 prevents the expert from telling the jury whether or not a defendant had the required mental state for purposes of a specific crime. That's up to the jury to decide. So here, the prosecution says the defense failed everything. Here, the prosecution says the notice was untimely, meaning it's coming in too late in the lead up to trial. This is an improper justification defense. It's irrelevant. It's unreliable, especially because the government claims there's no direct link between the mental health evidence and negating an essential element of the actual crimes that Combs is charged with. They claim that what Combs is arguing is way too general and it's confusing and it's not going to be helpful to the jury. And just going back to one specific line in the government's filing for why this testimony is inadmissible and why this doctor should not testify, it quotes a prior case, but it reads, "Thus, the usefulness of the expert testimony in determining whether the defendant was lucid during the course of his participation in a complex multi-year scheme is substantially reduced." And moreover, they claim that this doctor's testimony would violate the rule that I mentioned before about how an expert can't say definitively whether or not the defendant had the required mental state. The government complains that Dr. Aoun's testimony is unreliable because he didn't examine Sean Combs. He only analyzed certain medical records. And the government says that's not enough. So in conclusion, the prosecution argues that Dr. Aoun's testimony should be excluded, or they're asking the court to hold a hearing about the admissibility of this testimony. It's called a Daubert hearing. So I'm not going to...
Now, so some people feel this is Diddy kind of grasping for straws here because he's trying to introduce possible defenses to as almost like a safety net that even if he can't fully defend himself on some of the things he's alleged to have done, he could be like, well, I ain't do it in a right mind. You know?
This took me hours last night to go through all of these Diddy filings, and I was snacking, I was eating dinner, and I'll tell you what, I try to eat clean, I try to eat healthy, but shopping for healthy, I feels like what the defense may be suggesting is, hey, jury, because of drugs and alcohol, or something else, he didn't have the required mental state to commit these crimes. Am I understanding that correctly?
Jesse, you nailed it. And that's exactly what the defense is trying to do here. And we all know that voluntary intoxication is not a defense to a criminal offense. So, drug use, alcohol use. Yeah, if you're drugged, sure. But if you voluntarily take drugs, that's not a defense. So, what the defense is trying to do here is force a square peg through a round hole. Because, like you said, it's also well established that an expert or any witness for that matter can't testify to a defendant's criminal state saying they intended to do this or they did not. So I think the judge is going to exclude this particular witness, setting aside the Daubert hearing, setting aside his or her qualifications or even foundation, because this individual apparently reviewed some other records, didn't examine Combs himself. So for all those reasons, I expect this witness to be excluded. And like you said, Jesse, there are plenty of federal rules and cases that support that exclusion.
I feel like you're right. I feel like the judge is going to agree with the prosecution here, although it does make me wonder, the defense arguing this, and again, so much of this is redacted, but assuming we're right, does this feel like grasping at straws by the defense to go with this defense?
It really is swinging for the fences here. And the problem with this type of defense also is you're really admitting that Combs did all this, right? And he just didn't know what he was doing, essentially. That's the defense. You're focused on his intent at the time.
But not really.
And like you said, maybe if there was one episode where he wasn't lucid, maybe a jury or a judge might consider it. But we're talking about a conspiracy.
Yeah, that's a good point too. If you're trying to say this nigga was off drugs, not in his right mind, there's years. There's almost like a decade of things, and the thing with the RICO charge is about a pattern of behavior. So unless you admit that this dude had problems for years, but then you probably have to show some type of real proof that he really had a problem.
Conspiracy ranging decades here. Is the argument that he was under the influence of drugs for all these freak-offs, and when he entered into this conspiracy and when he was procuring these women and men to participate in these sex acts, and when he was completing the acts? Let's not forget the freak-offs lasted days. I just don't see it in a case like this.
By the way, so much of this filing, and a lot of the filings, is still redacted. In a few weeks, are we going to know everything?
Well, if the evidence comes in, we will absolutely know everything because, of course, trials are public. And unless there's some evidentiary issue like a hearing that's going to be outside the presence of the jurors, we're going to see and hear everything that comes into evidence in that federal court. But obviously, if something's excluded in some pretrial filing, we're not going to hear it.
Just to be clear, see everything. I mean, there's no cameras in the courtroom, but there's going to be reporting on it, and maybe some exhibits will be released. Possibly not, but there'll be a lot of reporting on it. Okay, so I want to move on to another argument from the prosecution. So not only do they argue that...
Chat, my bad if you see me like kind of looking elsewhere. Y'all think I should interview this dude? He hits me and he wants to do an interview with me tomorrow.
This is your mom's. I was watching.
Yeah. Go Yayo wants to interview. You should do it, right? This is W, right? Yeah, I'm setting it up with him right now.
That this doctor's testimony should not be allowed at trial. The jury shouldn't hear it. But they also filed a motion arguing the testimony of another defense witness should not be allowed. And this is Connor McCourt. We've talked about him before. So he is who the defense claims is a forensic video expert who's going to testify about the infamous footage of Combs purportedly beating Cassandra Ventura in a hotel hallway back in 2016. Remember when CNN published this footage? Apparently there's copies of it. Apparently there were cell phone videos taken of it. Apparently there's raw footage of it. But essentially the defense wants to challenge the authenticity of this footage. And it's not surprising because it could potentially have quite a powerful impact on the jury. Remember, the prosecution claims this proves Ventura, who we believe to be victim one in the case, was running away from Combs and a sex worker during an infamous freak-off. So, i.e., forced commercial sex work, sex trafficking, right? Now, the defense seems to want to call Mr. McCourt to make the argument that the videos the government will rely on are not reliable, that some are artificially sped up, they're distorted, including cell phone videos that make Combs look more stocky and more imposing. There are inaccurate timestamps. In other words, these videos, whatever videos are actually published for the jury to see, they don't accurately portray what may have happened. Now, the prosecution argues, like they did before, the defense failed to provide
with the government.
Okay, so y'all kind of get the gist. Diddy is trying to use a wide range of pre-trial strategies that they could, again, this pre-trial motions and hearings is to determine what's going to be allowed or what's not allowed. And Diddy's trying to have some defenses that could possibly sympathize with the jury or have the jury sympathize with him in case they do think he did some of this shit. Now, I don't think he's admitting that he did the shit because he would have just said straight up insanity or just like really go stronger for I was mentally incapacitated. But he wants to have a safety net. And it's very clear here after Diddy just turned down, he turned down a plea deal, which, by the way, shout out to my man Law Ronan, which is Bradford Cohen. He even said, here we go. He said about Diddy rejecting the plea deal, he says, trust me, the Southern District of New York gave him an offer that was easy to refuse. My guess is a plea to the sex cases and a 10 to 12 year sentence. I think the case is interesting because of many strategic decisions that are going to have to be made regarding the anticipated testimony, in addition to the surprises that I'm sure will all come out at trial. Now, let's think about and go with what Bradford Cohen is saying. Do y'all think that if Diddy took a 10-year sentence, given everything we've heard about that possibly could come out, like we hear so many victims, this and third, is that an L? I mean, he's kind of been locked up, like, I don't know how long he's been locked up. He's been locked up for like damn near close to a year. If he took a 10-year sentence, if that was the plea deal, he would have to do 8.5. He already kind of did one. In 7 years, he would be free. If he plays and rolls the die, he's going to be looking at probably minimum 20 years. Diddy is like 54 or 56. Let's figure out how old he is. How old is Diddy? He's 55. In 20 years, he's going to be, obviously, well, let's do 16 years, right? Let's say 15 with the 85%, mandatory you got to do. 15, that would be, I can't do math now, 70. So if he takes a plea, you do half the time that you would probably normally get if you blew trial. Do you take the plea and have to do 7 more? Or do you try to beat it? And if you beat it, obviously you get out immediately. But if you don't beat it, you're going to get double what the plea was kind of offering, right? Interesting. So that's kind of what's going on with the Diddy case. Let me see. What the hell?